because I'm notorious. So, but that's good. But okay. Yeah, I think more. Let me just see here. I think we do have people coming in. I think we're allowed. We can see them now. Okay, and they can see us. Okay. Hello, everybody. Okay. I see you, buddy. Thank you. Okay. All right. Okay. Well, I'm happy to start, and I know people will be coming in and they'll catch up. And we'll be able to at least go through Q&A if they have questions about things that we may have mentioned. So welcome, everybody. Very, very excited to have you join us at tonight's presentation. This is something that we've been talking about and working on for a couple of months. So we're really excited to have everyone join us tonight. I'm Christine Matus, and I am here with Adam Dayan, and we're here to talk to you about special education law and special needs planning, and just excited to be able to share some information. Before we begin, just a little bit of housekeeping. So if we can, I just want to make sure everybody can see me, hear Adam, can see Adam. There's Adam, and we have Chris here, because nothing is worse than going through a whole webinar and nobody could hear anything and see anything. So if you can, in the chat, if you can just put a Y, I would appreciate that. So I can just make sure we're being heard. Oh, great. Thanks, buddy. Okay, good. I appreciate that. Oh, thank you, Claire. Thanks, Chris. Okay, good. Excellent, excellent. Second thing, questions and answers that we're going to be providing throughout the presentation. If you have a question, I think that Adam and I were saying that it might be easier if you put it in the Q&A section. When you look in your panel, there's a section, you click Q&A, and that's where we can put our questions. I know some of you have already submitted questions ahead of time, so I have those. And if for some reason, if I miss something, put it in the Q&A so we can make sure to cover it tonight. But we're really just excited for all of you to be here tonight. I think this is something that a lot of us, especially as parents, we think about. But when we try to look for information, it's overwhelming. Sometimes we don't even know what we're reading and we don't know where to go. So I think a great goal for tonight is that all of us will work and walk out of here with a comfortable knowledge, a comfortable understanding of some of the terminology that you hear when you hear special education law or when you hear special needs planning, because these are big topics in our lives when we have family members who are disabled and have challenges, and we want to make sure that we're doing the right thing. But it all starts by really understanding what are the things that we're talking about. So really can't wait to get started. Very excited to see everybody here. Thank you again for joining. So, and joining us also is Christine Karen-Sehad-Gursky. She is an attorney in our firm. Some of you probably already met her. If you haven't, you will. So Christine is going to be helping moderate, and she's also going to be making sure we didn't miss any of the questions that you may have or clarify some topics that we may have mentioned about. So Chris, take it away.
Good evening, everyone. Welcome to our webinar. Just wanted to introduce myself. As Christine said, I'm with the Matus Law Group. I do a lot of special needs planning, general estate planning, guardianships, probate matters. But I am just, really excited for you to be here today because you are going to have a very special evening with two wonderful and compassionate attorneys who've dedicated their legal careers to helping individuals with special needs and their families. So first person tonight, I'm introducing Adam Dayan. Mr. Dayan is a graduate from Yeshiva University's Benjamin Cardozo School of Law, where he was a published member of the Cardozo Journal of International and Comparative Law. Prior to that, he graduated summa cum laude from Baruch College, where he was a Herzog Scholar and member of the first graduating class of the Macaulay Honors College. He is admitted to practice law in New York, as well as the U.S. District Court of the Southern and Eastern Districts of New York. Mr. Dayan began his legal career as an associate at a law firm known for its work in the area of special education law, where he represented families whose children had a variety of special needs. And he's moved on from that position. And in 2009, he pursued his dream of establishing his own law practice. His practice is currently based in downtown Manhattan, lovely office, gotta visit him, focusing on representing individuals with a wide range of special needs. On the nonprofit end, he's an active member of the Council of Parent Attorneys and Advocates, which is a group that strives to protect special education rights and secure excellence in education for children with disabilities. He is also a board member of the Repertorio Español, where he serves on the board's education committee. And just a little bit of tidbit about Adam. He is married, he is his wife, and 3 lovely children who reside in Manhattan. So Adam, take it away.
Oh, Adam, thank you so much for joining. I mean, really, we're just so happy that you're able to share your expertise with our families, especially when it comes to special education law. So I guess, what I'd like to start is that, again, for me also speaking as a mother and who has a child in the education system, there are times we may have issues, may have conflict, or just need to know what to do when we're having some problems with either the school system or maybe a plan that was supposed to be put in place. I guess the first question that everyone always has that I see, Adam, is where do we start? Where do parents begin when they have an issue?
It's a great question. And I just want to thank you for having me and for doing this. And I think events like this are so important, and I hope it's helpful to everyone who's listening. In terms of where to start, I mean, there's a lot to say. I think it's really important to get an understanding of what's going on with your child. And there's various ways to do that. Obviously, you want to listen to what the classroom teachers are saying about your child, and you want to pay attention to what your child is saying if he or she is complaining about certain subjects or areas. I think that we're going to speak a bit about evaluations, and evaluations are a key piece to this puzzle. We can go in whatever direction you like with that, but there are objective neuropsychological evaluations that you can obtain, which help you really understand what's going on with your child on a lot of levels. And so if you are expecting having a meeting with your school district, if you expect that you're going to be able to, you're going to be speaking with your classroom teacher, I think having a thorough evaluation that gives you objective information about what's going on with your child can be very helpful. And a lot of times that's a great first place to start, getting a comprehensive evaluation.
And, again, these evaluations, are they a big piece of what they need, Adam? Like, is that vital and important that they should be focusing on?
It is vital. And I think parents who have children with challenges need to know what their rights are. Being informed about your rights is top priority. And one right that you have is getting evaluated to understand what's going on with your child. And that's something the school district is obligated to conduct. Sometimes they don't always do the greatest job with the evaluations. And so you may be able to pursue a private evaluation at the school district's expense without having to pay for it yourself. But having a good evaluation is absolutely vital because it's going to evaluate your child in many different areas, academic, cognitive, various other areas like organization, planning, memory, processing speed, things that are so important for functioning in a classroom setting. And then there's going to be recommendations. And any good evaluation will have program recommendations, giving the parent, you all as the parents, a sense of what your child needs so that you can go into a meeting with a classroom teacher or a school district, for example, and say, look, my kid needs to be in a classroom of no more than 12 students because larger than that, it's too overwhelming. Or my child requires this specific methodology and I need to make sure that he or she is getting that methodology. In a good report, this is all going to be spelled out and it gives you the blueprint to have those conversations.
It's amazing to know. And so Typically, I know that when I'm looking at what is good for my child, a plan, Adam, it's at the IEP meeting. So I was hoping you can explain to parents who may not have done it, or maybe have done a few, or those who are in it, like a nice refresher, what should we expect in an IEP meeting?
Sure, absolutely. So the first thing I need to say is that we practice predominantly in New York, but what's interesting about this area of law is that it's all based on federal law. And so the system in New Jersey is going to resemble the system in New York, is going to resemble the system in Pennsylvania. There will be nuances because every state has its own statutes, regulations, and policies. But there's a lot of similarities because it's based on federal law. And so I'm going to try to speak as broadly as possible so that it applies to everyone, but you do want to check your specific locale. As far as the IEP meeting, the first thing to know, just really simply, it's a meeting between a parent and the school district. And one important thing to remember is that parents are equal members of this team. And so you might think you're going into this meeting and the school district is the only one entitled to a say in the matter, but that's not true. Parents have a say in the matter, and they get to speak up about what's going on with their children and what they believe is appropriate for their children. And so generally speaking, you sit down at this meeting. From the school district, there's usually a psychologist, a classroom teacher, you might have a general education teacher or a special education teacher or both. If there's therapies being provided, or there might be a need for therapies like speech, occupational therapy, physical therapy, anything like that, you might have those providers as well. And then typically a district representative, someone who is supposed to be familiar with the resources out there and can make recommendations about what's going to be appropriate for the student. And so it's meant to be a conversation. Presumably there will have been some testing done, which is the basis of where to start, because they need present levels to understand how the child is functioning. And then from those current levels to establish goals. What's going to happen over the next 12 months in terms of reading, in terms of math, in terms of social skills, in terms of speech and language development. And so there need to be objective measures resulting from this meeting put into the IEP itself, which is a legal document, to guide the progress that the student is expected to make so that parents can determine, is my child progressing or not? And so you're going to decide on a classroom type that's appropriate for the student at this meeting.
Right.
All different kinds of classroom possibilities. Presumably the team is going to say what related services or therapies are necessary, and also the frequencies, how many times per week, and the duration. So the team might decide that the student needs speech therapy 2 times a week for 30 minutes per period. And then any other supports or services that the student requires, that could include transportation or paraprofessional or after school supports or anything along those lines. It's very broad, should be encompassed in that document as well. And one more thing I'll say, and then I'll pause for you, Christine, in case there's any follow-up questions. Parents have a right to bring their own people and experts to the meeting. And so if you've done private evaluation, or you've been working with a tutor, or there's someone else involved in your child's life who can give information about what's going on with your child, those people have a right to be at the meeting to provide input to the team.
Now, I was curious. So, as you're preparing for this IEP, what are probably, in your opinion, Adam, are things that parents should, like just some basic tips of how they should know about, like big things that they should be aware of before they enter into this meeting? I that was one thing that you mentioned, that they could bring their own. I love that, because a lot of parents may not be aware of that. It's a big deal.
Yes, some other basic points. Parents don't have to agree to anything on the spot, no matter what the school district team tells you. And so you shouldn't feel pressure that you have to come up with an answer right now, or sign an agreement with the recommendations. You have a right to wait for a physical copy of the IEP, review it carefully, consult with your significant other if you choose to do so, and then get back to the team about whether you're in agreement or not.
Mm.
You have a right to disagree with the recommendations. And so if the team says, for example, we believe your student would do just fine in a general education classroom, you're really adamant that your child needs 12 students, one special education teacher, and an assistant teacher, for example. Well, you can speak up and express that disagreement and reject their recommendations. I think those are some very basic points to keep in mind in making sure you're making the right choices for your child.
Absolutely. And I think, what comes to mind is that when you said that you can actually reject it and you don't have to accept it, but there's, I'm sure in your practice, Adam, there's a point where there's just not a meeting of the minds, how a parent wants something and the practitioners in the school system have a different opinion. There might be need to bring in, more help for the parent. So I guess I'm always wondering, when do they engage someone in your profession, a lawyer, to help them? Is it good to have it right away? I mean, there's so many different aspects to this. You always want to know, when is the right time?
Right. So the first thing I'll say is that the federal law that set up the whole system for parents to pursue their rights and what children with disabilities are entitled to is very generous in terms of the protections that it affords to parents. And so one example is there's a whole impartial hearing process so that parents who feel aggrieved by the team's decisions can appeal those decisions. And so I won't get into the technicalities of the complaint and what needs to go in it and that whole piece. But just to keep it simple, you can file a complaint challenging the school district's actions and recommendations, and then have a day in court in front of an administrative judge who can look at your situation objectively and say, did the school district team follow the law or not? In terms of when to engage an attorney, I think it matters where you are and what school district you're dealing with. As I said earlier, we practice in New York and predominantly in New York City. And New York City, the 5 boroughs function as one school district essentially. And so for our cases, it really pays to plan in advance and strategize. And so we always encourage our clients to come to our office, at least for a consultation early, because at least you're getting information about what your rights are and some advice about what you should be doing. And you can consider it and decide if you want to follow those suggestions. But we've seen a lot of families who came later and they wanted to wait and see and give the public school system a try, for example, and it didn't work well this year, but maybe next year will be better. There was some progress, maybe next year will be a lot more progress. And those years pass by quickly. And sometimes you get to a point where the child is dispirited and dejected and giving up on school and himself or herself. So at the very least, you want to know what your rights and options are. And it helps to understand the system and to know what resources are out there. And so even as something as simple as the evaluation I was talking about earlier, it would behoove parents very much to know who to contact for an evaluation and whether that can be funded by the school district to get a pulse on what's going on with the student. And if you do that early, then you're in a much stronger position to advocate for your child.
Yeah, I think you're right. I mean, planning early, and it doesn't hurt to, to contact an attorney like yourself to find out, where you are in the matter, because sometimes, waiting can be a problem. There are times parents also need the help of an advocate, Adam. When do you have an opinion on when and how they work, to be quite honest? Just to find out, are there situations that's advocate only, situations lawyer only?
So in some areas, you can practice in this field without being an attorney. And so what advocates typically do is a lot of the initial prep work, helping parents get started with the process. And sometimes that means attending IEP meetings, or it could mean visiting recommended public schools to determine if they're appropriate or not, or making suggestions about what schools to consider or what services to be thinking about, or writing letters in consultation with the parents to communicate concerns to the school district. You know, from my standpoint, I guess this is a little bit self-serving. I am an attorney. I think there's an important difference between advocates and attorneys, because advocates don't have that legal expertise to understand the nuances of the law and how to present cases to administrative judges, or what the case law is showing as it's always evolving. And you know, there really are a lot of nuances. You need to be up to speed on those nuances. You have to be specializing in this area only because of how often and the various ways in which it changes. And there are some lawyers, I will say, who serve the role as advocates, right? If you're looking for someone to help you with those early stages, some law firms like ours will do that initial work on your behalf. And so that's something to keep in mind. But, you know, it may vary from place to place. And at the very least, you want to be speaking with someone who's knowledgeable so that you're not on your own, because it can be very overwhelming.
Yeah.
And there's a lot of emotions involved. And sometimes school districts don't give out the right information. And so parents may be relying on their school districts thinking that they're getting all the right pieces of information, but it's not always the case. And so you want to be in the know and speaking with people who are knowledgeable about this practice area so that you can proceed appropriately.
And that's frustrating, right? Because you do turn to the educational system, you rely on them for many things. And then when it especially comes to this, some of the most important issues that are happening about how they can definitely help their child, and knowing that you may be given wrong information, it's disheartening. It really, it's devastating, to be quite honest. So what I was hoping to also add, if you can help out, there's a lot of vocabulary in special education law that comes up. And I've known it myself too. There are times I look things on Google, and I look things up, and some of these phrases come up. And again, for me, not being a special education lawyer, you know, it's a little challenging. You know, you see these terms, but as a mom, I started to get comfortable with it. But I think, you know, I would love to hear from your point of view, Anna, if you can give a little bit more clarity when people hear these terms that are very often used, like, for example, the free appropriate public education, you know, FAPE. I mean, I have to say, I see that a lot. I was just curious if maybe you can elaborate more, that, you know, when that comes into play, what it, you know, and just helping clarify it to our parents.
Sure. That's a good one. There was a federal court judge who actually referred to this practice area as alphabet soup.
Oh,
So you're not alone in thinking that there's a lot of, you know, letters and acronyms. FAPE, or free appropriate public education, is a really, really important one. In fact, this whole practice area is based on the concept of FAPE. And it basically means that your child is entitled to a free appropriate education at public expense. And I can tell you that appropriate is the subject of a lot of litigation in this area. So many of the cases out there have to do with, was this appropriate or not? And it's very common that the school district has a different definition of appropriate than a parent does.
yeah.
And so, you know, there are limitations on what a parent can expect from the school district for free. But the point I want to get across is that it has to be a meaningful education. And if there's minimal progress from year to year, or the student is just being promoted because his or her friends are being promoted, that's not enough. And it has to be, the program that the school district is creating has to be ambitious in light of the child's circumstances, and reasonably calculated to result in meaningful progress. And so that's a very important one to remember.
Yeah. Here's another one. I always see least restrictive environment. That's, I'll say, that I've seen that quite often as well, and hoping you can elaborate more on that.
Sure. So the concept behind least restrictive environment, or LRE, is that parents have a right to keep their children in the least supportive classroom if the child can make progress. And so I'll give you one example. A parent may say, look, my child doesn't need full-blown special education. If I put them in a general education classroom with some supports, maybe some pull-out services 5 times a week, or somebody by their side in the classroom to help with focusing and attention, they'll be fine. They'll be able to progress meaningfully. Well, a parent has a right to insist on that, and school districts have to provide it. And so, a school district may not want to, because it requires a little bit more creativity, and they have to shift resources around and really customize it to the student. But they don't get to say, we're not doing it. They have an obligation to do so if it's going to help that student progress. And the rationale is that it's beneficial to students to be around their typically developing peers, is usually the verbiage. And so for a lot of reasons, social skills, emotional skills, self-esteem. And so if that's possible and the student can progress academically, then the school district must provide it.
Okay. Well, yeah, and it's things that we can kind of figure out in our head when we see the term, but then when we hear it from your point of view, then you can see, and it's kind of a relief, I think, too, because you're thinking, okay, I see where this is going, which is right. That's the whole purpose of what we want. We want to see, how much more can we have them, thrive on their own if they can, and whatever supports can be, can be helped. So I love that. How about this one? Private school placement, things that you may have, again, things I've seen, where people, that's a subject area. And I think it's a topic that people are always wondering about if it's possible.
Yes, so our legal practice deals with this a lot. And the idea is that if a school district cannot provide a free, appropriate public education, they must fund the cost of a private special education program that's appropriate. And so, because New York City is such a behemoth, and in many cases is not able to get its act together and offer appropriate programs and placements, a lot of families wind up finding private schools that can meet the needs of the child, and then filing the complaint and following the legal process to get reimbursed or funded for the private schools. And so that's the idea behind it. And if you're in New Jersey and you're dealing with your school district and they really don't have their act together, they can't recommend an appropriate public school program, you may want to be thinking about, hey, is there a private school out there that can meet my child's needs that I may be able to get funding or reimbursement for?
Oh, wow. Okay. And you're right,
Yes.
because, oh yeah, go ahead, Chris.
Excuse me 1 second. It
Yeah.
just kind of leads on to one of the questions that we have from, from
Good.
our
Thank you, Chris.
participants. And that question is really regarding what Adam was just talking about. So Adam, with regard to, the private school, if the child is already in the system, okay, but the parents are not happy with that school and feel that the child's needs are still not being met, the educational needs are being met, can they find and choose another private school education wherein, the state or, through this program where this, particular participant is part of the CBST, is there an option for these parents to find a better private school that they feel will meet the child's needs?
Okay, so I want to make sure I'm understanding the question. I heard you mention CBST, right?
Mhm.
And so
Right.
I'm understanding the question to mean the student is in an approved private school and
Yes.
now is interested in switching to a different approved private school. Am I correct?
That's correct.
Okay, so I think that's an important distinction. Without getting too technical, there is a difference between an approved private school and an independent private school. But staying on point, I will say that yes, it is possible to switch from one state-approved private school to another. It's also possible to switch from a state-approved private school to an independent private school. And it's also possible to switch from an independent private school to a different independent private school. So as the parent, you have a lot of flexibility in terms of where you place your child. There's no, if you do it properly, there's no disadvantage to acknowledging that you want to move your child to a different program that you think is going to be more suitable. And just because you determined that school A was suitable in year one, doesn't mean you have to stay with that forever. If you determine in year two that a different school is appropriate now, then there are ways to put that in place so that you can make the switch and keep funding in place.
Thank you, Adam.
Excellent. I think were there other questions, Chris?
There are actually, and this is, I was just hoping if you, let's go to the next one that I have here.
Yeah.
So we have somebody here who is a special ed itinerant teacher, SEIT, working with pre-K children. He works in Staten Island. The Staten Island violates federal law for many of the students. DOE does not always provide OT, PT, and speech services that are mandated in the IEP. So Sam's question is, what advice can I give my parents?
Okay, so anytime a school or school district is not implementing therapies that are required, there's multiple things that you can pursue. I mean, one thing that you can do is seek makeup services for what was supposed to be provided but wasn't provided. You could let the school district know that there was a failure to implement these services, and then proceed to put your own people in place at public expense. You might decide that you have to change schools and find one that is able to implement the services. And we can talk about whether that's going to be a public setting or a private setting, but arguably you might be able to find a private setting at the school district's expense. So I think there's a lot of options. It's important to nip it in the bud early. I mean, you want to limit the disadvantage to the student, obviously. B, you want to start creating a history of what is wrong and putting the school district on notice so that if you need to demonstrate later that they were notified and didn't rectify it, that you have a record of that. And there may be an element of strategy or planning depending on what you're hoping to pursue, right? So if you were talking to a lawyer, the lawyer's advice would probably be different if you were thinking about going down the private school route than if you were just interested in pursuing makeup services for the therapies that were missed. And so, you know, in that regard, there may be an element of strategy depending on what you want to do.
Very
Thank
good.
you. That's a great way of approaching it. And Sam, I think that would be a, got a little guidance to the parents that you feel that are, going through this. But more importantly, I feel it's just important to also to speak to an attorney who knows this area of law. And because, sometimes when we're doing things individually, we're not really sure, what to advise other people. Best thing to do is to really have them speak to an attorney. I
And
always
Chris, if I can just add, we're seeing a lot more of this because of COVID. Schools are short-staffed and therapists are not in full supply. And so one of the ramifications is that more students are not getting what they're entitled to. And in extreme cases, you see depression and anxiety are up, and regression is more substantial than it normally would be. And many schools are really reeling from this pandemic. And I can tell you that New York has definitely put programs in place to make up for that. And based on IDEA, parents have a claim for makeup services. And so, and I'll just add one more thing, private school placements are up because parents are seeing more and more that their public schools are not equipped to provide an appropriate education. So you have more parents looking for private school placements. And so because of how things have played out from the pandemic, you want to really be paying careful attention. And if the needs are not being met, jump on it right away.
Here's a question, Adam. Can you tell me where I can find an advocate? Are they provided for free or is there a cost?
I don't know any advocates who are provided for free. You know, sometimes school districts will appoint a social worker. I think it's a social worker. A parent representative, I think, is the title. They typically have a social work background just to sort of be at the meeting, the IEP meeting, and provide some emotional support. But that is not someone who's going to be helpful to the parent in a real way. You need an advocate of some kind who's familiar with the rights in the legal process and can really stand up for the parent. So advocates that I've had, known, that I currently know, typically charge for their services. I hope that answers the question.
Here's another question from Sam. Are the attorney fees paid by the school district?
It can be. And I think that's a good question and an important thing to keep in mind, that there is a fee shifting provision under this law, which means that attorneys have the ability to recover legal fees from the school district if they're successful with the case. And one of the benefits of that to parents, and every firm structures their fees differently, deals with the fee shifting provision differently. So you really have to speak with the firms and do it on an individual basis. But typically, to the extent that parents have to pay fees, they're usually flat fees. So parents know exactly what their obligation is. They're typically heavily reduced fees, a fraction of what the cost of the case because of this fee shifting provision. And so, to parents who are thinking, I don't want to call a lawyer, hourly rates, legal bills, it's going to add up, and et cetera, et cetera. This is a different area of practice because of this fee shifting provision. So if you're feeling hesitant or daunted because of what you perceive as the legal fees obligation, get some more information first, because this is something that's very helpful to parents.
Very good. Did we miss anything, Chris?
Yes, there was a question out there about, if you're an adult and you feel that the system has failed you, what are the remedies? What options do they have?
I have to say it's not really our firm's area of expertise. We usually work with children from birth to the age of 21 or 22. There is a cliff. That's the phrase that's commonly used when an individual with a disability or special needs or challenges, however you want to phrase it, becomes an adult. There's a huge drop off in the services and funding that are available, and it's a big problem. Although I would like to think that at some point in the future, my firm will develop expertise to be able to help adults. That's not something that we do right now, so I'm not really in a position to comment on what's available. I will just say that in New York, there's OPWDD, the Office of Pupils with Developmental Disabilities. There's Medicaid. There's ResHab. There's things like that that parents may want to explore further. Adults may want to explore further, but I wish I could say more, but it's not our area of expertise.
Got it. Okay. All right. All right. So maybe at this point, Chris, we can transition to some special needs trust questions before we run out
Before
of
we do that,
time.
Chris, I
Oh, yeah,
have
go ahead.
one
Yeah.
person who wants
Yeah.
to ask Adam something, but she
Okay.
wants to ask the question herself. So would it be okay,
Yeah.
Adam? Allow her to talk real quick?
I'm a little bit nervous, but okay.
All right, give me 1 second. Okay, Carmen, I'm gonna allow you to talk, okay? Please go right ahead.
Hi, Carmen.
Hi, can you hear me okay?
Very good.
Hi, Carmen.
Okay, I'm sorry, I'm gonna, for some reason, my face, it's not showing. I don't know why. What do I do? So I lost your picture.
Oh, we can hear you though.
We
It's
can hear
Okay,
okay.
you.
now I see you. Okay. The question is this. I do have a special needs son and he is, he's actually autistic, but I believe that the driving force for him is fetal alcohol. Okay, which he is diagnosed as that. But on top of everything else, he is deaf from one ear. I have asked the school to see if they could give him classes for, to learn sign language, but they keep telling me that for children that are just unilaterally deaf, they don't do that. Is there something in the law about that?
I want to be helpful, but I think that your question is very specific. I would feel more comfortable addressing that privately. I would suggest reaching out after the webinar and I'd be happy to speak with you about your specific circumstances.
Thank you, Adam. Thank you so much for that.
And we'll give everyone's information, Carmen, how to contact Adam. We'll put it in the chat for you, okay, for everybody.
That sounds great. Thank you for your question, Carmen.
Okay, so let's switch over to the next area of law, which is going to be with Christine Matus. Christine is the owner and the founder of the Matus Law Group, which for more than 2 decades has served the residents of New Jersey in matters of estate planning and real estate law. In addition to general estate planning, the firm specializes in estate planning for clients who have a family member with special needs. Christine graduated from Jacob D. Fuchsberg Law Center, hopefully I said that right, at
Yep.
Touro College, and was admitted to the bar of the state of New Jersey and to the U.S. District Court of New Jersey in that same year. In addition to that, she's also a trustee of the Ocean County Bar Association, the Asian Pacific American Lawyers Association, and serves on the advisory panel of the American Bar Association. Christine is a strong believer in giving back to her community. She's been involved in several pro bono projects, such as with Mary's Little Children LLC, Salatine Light Community, and she actively volunteers with South Jersey Legal Services. Christine resides in Toms River with her husband and their 2 lovely daughters.
Thank you, Chris. That was kind. Thank you so much. So yes, as Chris said, I'm happy to chat about that area of law that I feel it goes hand in hand with what Adam does. Adam does a lot of the special education law, but as I'm sure you've seen, Adam, parents come to us and they'll have both of those issues, not only about what's going on currently with their children, but what can we do for future? What can we do currently? Right? I'm sure you've seen that.
Absolutely, for sure. And I think that has only increased during the pandemic because parents are really thinking about long-term planning, taking care of their family, what else can they be doing? So certainly, there's a lot of overlap there, and I'm really excited to be able to ask you some questions.
Oh
about
yeah. All right. Go ahead. Okay. Go ahead, Adam. All right. Sounds
So
good.
why are special needs trusts an important part of planning for the future?
So as we are helping our families grow and we're doing things such as going to Adam to make sure they're getting a great educational base and making sure they're getting the services they deserve, we also have to look at the other aspect, that as our family members are getting older, there are things that they will need protection from and need to make sure they're insulated from. So if we are concerned about a child or an adult child, making sure that they're protected, this is a tool. A special needs trust is basically a tool. It's a financial tool, and it does several things. One that I think is really one of the most important thing, it really protects our loved one from predators. We will create this tool and we can put assets in it, and we can make sure that there are certain people that we know, we like, and we trust are in control of it to protect our loved ones from people who take advantage of them. So that's one of the big, I think, hallmarks of this type of trust, that this tool. So a trust is a tool. But one of the things that we probably have seen with our loved ones is that eventually they'll be eligible for certain type of benefits, their entitlements, they're means tested, their benefits such as Medicaid, benefits known as SSI, Supplemental Security Income. Those types of benefits, as opposed to others, they're really based upon assets that are in our loved one's name. And it's a very low figure for now. They are trying to change it, which I hope, because really this figure has barely moved in decades. But right now, and I'm just giving you a generalizations, there's little changes to it, but for the most part, the rule of thumb has always been that we cannot have more than $2,000 in our loved one's name. And if we do, it will then disqualify them from those very, very important benefits. So when we're planning for our loved ones in the future, we have to keep that in mind, because if something happens to mom and dad or the loved one who's taking care of them, usually you would have, the next step is that I would love them to inherit, right? Have an inheritance. But if they inherit more than $2,000, we're going to have a problem. They're going to lose those very difficult to achieve benefits. I think all of us who have the benefits, they're hard to get. They didn't just happen overnight. You know, as much as we are in the year 2022 and we think there's so many advances where instant is great and instant happens, it doesn't happen in that world. If you don't submit the application and then within 24 hours, we say, you got it, you don't got it, whatever. It's months in the making, sometimes years in the making. So when we actually receive these benefits, Adam, we want to make sure we do everything in our might to protect it and we don't get disqualified. So the Special Needs Trust is a tool to protect those benefits, among also protecting them from predators. So that's why I feel it's very, very important to have. It's really a hallmark in planning when we have a loved one with a disability. So that's really why I think it's important, Adam.
It's such an important tool. And, so parents who are thinking about setting one up, where do they begin? And are there different kinds of trust that they should be thinking about? What's the first step?
Yeah. So when we have a loved one who has a disability, it is important to have it set up while we are alive, because there's implications of what happens when we have died and it needs to be created. And yes, there are different kinds of special needs trusts, but the main one that most of us should be considering that we should have for our loved one is called a supplemental needs trust. It also goes by another name, third party trust. And why do they call that? Because it's based upon where the funds are coming from. So I'll give you an example. I have two children, Emma and Juliana was born with Down syndrome. So as a result, there are things that we want to make sure that we protect for her. So we created that supplemental needs trust, also known as the third party needs trust. So it's created. And basically where it comes into play in our situation is, if something happens to both mom and dad, we would like the estate to be split 50% to Emma, then 50% to the supplemental needs trust of Juliana. That's how it's going to be set up, right? And that's how we would label all our beneficiary forms. That's how we want everything to be placed in there. And it's third party because the funds aren't Juliana's now. They're mine and my husband's. So we're the third party. And when we pass, that's where we're directing the funds to go into. And in the third party type of trust, one of the hallmarks is that there is no payback clause. What's a payback clause? That's a clause that can be placed in a trust where it says, if my loved one dies and there's money left in that trust, the state can dip in and take it to reimburse themselves for all the benefits that were provided to our child, because the state is saying in basic terms that, you do have money to pay for your health and for other things. We really shouldn't be giving you Medicaid. We really shouldn't be giving you SSI, that extra, now it's like $800 a month. But because you had that trust, we're going to have a payback. But this third party, when we create it, when we're alive and we're placing it right now while we're alive, we can eliminate that payback clause. It's so important, Adam, because there's another type of trust that can be created. It's called first party trust. And that's when the money is already in the hands of our loved ones. And when does that come into play? There's a couple of popular scenarios. One is an inheritance where perhaps mom and dad didn't plan, they didn't have time, they didn't know about it. Sometimes it's just all about education, right? But none of you are going to have that issue tonight because you're going to know. So we've had scenarios where people come to us and to say, our parents died, but my brother is disabled. If he receives his inheritance, Christine, he's going to lose his benefits. What do? We can create that special needs trust. Great. We're doing it after the fact, but here's the problem. There is a payback. That seems to be the consequence. Where we create this trust after you have passed away, we can still do it, but now we have a payback clause. And if there's any money left in that trust, that money is going to be reimbursing the state for money that they had provided for the benefits. Also, first party trust is a little more restrictive about how you can use the funds, and I won't go in, that's a whole webinar in itself. But what you want to make sure while we're all on this webinar is that if you have to consider a special needs trust, you want to do it now while you're alive and you're getting the third party. You really are. And that just leads me to something I just want to go into, Adam. That's why it's important to go to practitioners who do this all the time. Oftentimes, Chris and I are happy to review trusts that may have been created a long time ago or by someone else, and usually they're great. But there are a handful of trusts that we look at and we could tell it was not done by someone who does this a lot. It was not done by a specialist. It was not done by someone who does, who concentrates in this area of law. And how do we know it? Well, I'll tell you right now, I'll look at that payback clause. That's a big red flag. I'm like, why is this in here? And this was, you created for your child. Why? There's no reason for you to have this. And boy, isn't that terrible if we didn't know that and they pass away? Well, it's in it. And we can't, once you pass away, I can't make changes to this trust. And no one can say, you know what, that shouldn't have been in there. Well, it's too late. So again, if you're going to have any of this done, please go to professionals who do a lot of this, and I'm letting you know it's that important. There's other nuances that really make it important to make sure to go to people who do this. The third type of special needs trust is called a pooled trust. So that is a type of trust where perhaps we're not talking about a lot of money and what's a lot, and it really varies, and that we may not even have a trustee in mind. When we create these tools, we're creating it with the idea that I'm creating it, so I'm in control of it as I'm living. I'm the trustee. I'm also the creator, also known as trustor, other names. And when I pass, I am nominating an alternate trustee. And so in my situation, it's my brother, right? And it would be nice, and Emma gets older, maybe she'll take over as trustee. Well, no, we'll see. We'll see how that goes. But again, you want the alternate trustee to be, again, someone you know, like, and trust. But perhaps we have a situation where we don't have someone in mind. Perhaps we have a situation where, we really don't have a lot that we're thinking about, but it is above the $2,000 mark. A pooled might be an interesting alternative, but a pooled trust typically is only run by a specific company, a nonprofit that will do it. And the way it works, it's several accounts. So you're all put in kind of a pot, right? But they do designate what was your amount. However, when you pass away, if there's any money left in your account, that is that stays with the company. You cannot designate a beneficiary. With the third party, we would say, God forbid something happens to Juliana and there's money left in her trust, balance goes to her sister Emma. I can do that now. Pooled first party, we cannot designate that. So it's just something to keep in mind. What's best depends on the circumstances, how much funds we're talking about, and who's involved, and what are the ideas that we have for the families. But it's good to think about. So, but
Sure.
really, for the most part, families should be really focusing on the third party, Adam. That's really the main thing to take a look at. And that's why I think it's important. I think this might be a good segue to a, oh, go ahead, Adam, go ahead.
I was just gonna say, so important for families to get that information early and to have the opportunity to plan properly.
Yes, early is the name of the game. Well, you can think it thoroughly. You don't feel pressure. We've had situations where things are happening, maybe a family member, mom, dad, not doing well, health is declining, and we're trying to put these together in a rush, and we'll do it. But it's upsetting. There's so many questions they may have, and but they won't get to it because they just feel like, let's get it in place, Chris, just do it. But this is a good segue to one of the questions I had seen earlier. Laura, so we just talked about special needs trust, but there's also something called an ABLE account, and what's the difference? And why would we have both? So an ABLE account, Achieve a Better Life Experience, really a great tool that was created very, very recently. And it's a way to promote and to help our loved ones to be a bit more self-independent, self-determining, where we can open up an account. It can serve almost like a 529 college plan. Some of you may be familiar with that, right? And there's many different plans. Each state has its own plan. And it depends on what you're looking for. What are some of the consequences if we don't use up all the money, things like that. So an ABLE account is the same way. Each state has its own ABLE account. So you want to go to people who are familiar with it. There are financial advisors out there who are very, very familiar. One of them was just on the line, Buddy Pearson, and he really knows about ABLE accounts. He studied each one. So an ABLE account is an account, and there are some requirements in order to get it. To have an ABLE account, your disability should have been diagnosed. It should have set in before the age of 26. And you cannot put more than $15,000 in that account per year. And it cannot accumulate to a certain amount. If you have about $100,000 in that ABLE account, you will start to lose benefits. Once it gets to more than 200,000, you will lose all your benefits. You can only have one ABLE account, and there is a payback, right? That's the one thing that a lot of people aren't aware of. So we have these accounts, and you can open them. And what I like about them is that you may be able to have your loved one learn about money management. There are ways and mechanisms to limit how much you can give them a debit card where they can have access to it to a certain amount. But you have to be careful with that and making sure they're able to do that. If they can't, then you're in charge of it. Another reason that parents may like or love, or guardians may love to have an ABLE account is that you can use the funds in an ABLE account for more things than a trust, right? But again, being wary about the payback clause and being wary about how much we have in there. So is it possible to have both a special needs trust and an ABLE account? You sure can. And again, depending on your circumstances, we had a case where we had the special needs trust, and it was funded. Parents decided to put money in it already. And they had their son living in a place, and they realized that, oh, you know what, rent is, for example, using easy money, $500 a month. But to get the bigger room, it's $700 a month. But unfortunately, his SSI money, right? SSI is used for shelter. It's used for food. SSI money may not be enough at the time. So they were thinking of dipping into the trust. But the better solution would have been dip into the ABLE account. So you can transfer money from your special needs trust to an ABLE account and then use it to pay shelter, no change in your benefits. Without that, there will be a change in your benefits, a modification, no more than 1/3 of what your benefits are if you use money from your special needs trust and you're receiving SSI money. So those are it gets a little complicated, But yes, there is ways to use the special needs trust and the able account together. There's many other ways. And again, that could be a whole separate webinar, but it's a great tool. I find it, but one thing to let you know, you can't get an able account and put money in the trust. They don't like that. It has to go the other way. But great question, Laura. I hope that made a little bit of sense for you, Laura, for you.
We get those kinds of questions from clients and parents who contact our office as well. If they decide to set up a special needs trust, what can it be used for? So for example,
Yes.
a common one is, can they use it for medical benefits or services?
Yes. And so in the big picture, again, if it's a third-party trust, that's a little bit more liberal, how you can use the funds. So typically, if it's for medical needs that are not covered by Medicaid, then definitely you can use the trust for it. You always have to look at what are the benefits in place, what are the benefits paying for first. They take precedence. That's how it goes. After that, we can dip into the trust. If there's an overlap, it could affect benefits, but it really depends. Most parents are using the trust money to buy special equipment, that special apparatus, the special type of wheelchair. You can buy the special van, the mobility vehicles through the trust, and that's fine. There's nuances to it, but in general terms, Adam, yes, you can definitely use it for that. There's a question by Deborah. Which kind of trust is recommended when the disabled individual receives a significant settlement, and what the money can you use for? Great question, Deborah. So when we receive a settlement, you're looking at a first party trust. So long as that individual is 65 years or less. When they're older, our choices are limited of what to do. Chris and I have experimented and looked into other avenues for that. But if we're looking at someone, within that age range, you're looking at a first party special needs trust. And again, looking what kind of benefits are in place. If that person's receiving Medicaid and SSI, again, the trust money from the first party cannot be used for food, cannot be used for shelter. It can, I should say, but then you're going to look for a decrease in their benefits. So I do have clients who say, you know what? I do need some help with the rent or with the mortgage that's considered shelter. So I will take money from my trust. But if they're only going to decrease my SSI money by a third, looking at all the benefits I get from the trust sounds good to me. So we have to weigh each situation. But you can also, like I said, buy a car with the first party trust. You could make improvements in your home with the first party trust. And again, I'm talking in general terms. There's a lot of nuances to it. So we do have to be very careful. I would really request that you talk to a professional before you do any of those big ticket items like buying a house, because there's a lot to consider. And that again could be another webinar, Chris, about when you're buying a house.
Yes.
But great question, Deborah.
There's a couple of other questions
Yeah.
there, Chris.
Go ahead. Yeah.
There was one from Tula, and she initially said she wanted to know how much money is needed to set up a special needs trust. And
okay. So, there are different types of special needs trust, Tula, and it also depends on what are we looking for. So, it's a great question. To initially open up the trust, you don't need to have to fund it. You don't need to have any funding available immediately. It's always important to have it in place, ready to receive funds. So, again, a special needs trust can be thought of as an account because you are opening it in a financial institution, but there typically is no minimum that you have to put in there to keep it open. If there is, it's very minimal, but there's no initial, funds to have it funded. To create the trust, again, we highly recommend you go to a law firm to do this. It really varies because, again, it depends on the individual, what their needs are, what we see the situation is with the family. So it's a little hard. So it's a great question, but we encourage you to reach out to a law firm such as us, and we're happy just to ask a couple of questions, and then an estimate is usually provided to you, because we never want to give you an idea about something that you may not need or something that doesn't make sense. There really needs to be a little bit more facts with that. But to fund the trust, there's no minimums and there's no maximum with a trust. Able account, there really is a maximum, right? As we mentioned, but great question. I appreciate that, Tula. Thank you.
Christine, you had mentioned that the ABLE accounts vary from state to state. Every state has its own version. Do the parameters surrounding special needs trusts vary from state to state as well?
So yeah, with a trust, what you always want to be careful for is that the benefits that you are getting from each, because each state has its own nuances with benefits. So I had a client in New Jersey moving to Texas, and it just seemed like, and they have different terminology for the type of benefits. Important to get all your ducks in a row about what we need for those benefits to kick in, say in Texas, in this example. You never want to leave New Jersey and then you don't have the benefits and you go to Texas and now there's a gap. So you want to do all that homework ahead of time. And then you want to contact counsel in that state, because for the most part, the trust will be respected, but there may be nuances in it that you need to amend to make sure we don't have a problem if something should happen. So we always recommend to go to local counsel in that state. And we're pretty good. We have pretty good connections throughout the country. So if you're moving to a state, let us know. We can connect you to someone we know and they could tweak it, or at least make some recommendations of what needs to be done to make sure that trust isn't broken when you move to the state. But good question. I'm just looking to see if there's any other questions here. Claire, I think, saying, how does one know what special needs trust funds can be used for? Also, I opened a trust for my daughter and moved her 529 money into it. Is that allowed? Yes, you did the right thing, Claire, going with the second part of your question, because the 529 fund is now considered hers. And so if you can do that before it becomes hers, because you're creating it before she can use it, you did the right thing. So you that's allowed, and that's usually what we recommend when we see clients who have a 529 and they're thinking of creating this type of trust. But again, what the funds can be used for depends on, number one, what benefits we have and the type of trust we're creating. So third party, a little bit more liberal of what we can use for. But for the most part, if we're receiving SSI and Medicaid, SSI, again, you really got to be careful if you're using the trust fund money for food and shelter, because they will then adjust your benefits. But other than that, you can use the money for professional fees. You can use it for medical equipment that isn't covered with Medicaid, as I mentioned before. So there is a list. And, again, when we have clients who we help, we create the trust and we do give them information about what the trust money could be made for. It could be used for. You could use it for certain prescriptions and medicine, again, not covered by Medicaid, vacations. And it could also, if you need to pay for the one member to go with them on the vacation, that's permitted as well, right? Because this is to enhance their life. You need to buy that iPad. You need that's what for the most part, what these things can be used for.
Christine, I know you mentioned the different kinds of trusts. You spent some time talking about that, and you may have touched on this before, but I find that there's commonly confusion about special needs trust and supplemental needs trust.
Yes.
So can you just clarify again, are those the same? Are those different? If they're different, what's the difference?
If you're Googling, they're the same thing, to be quite honest. They use those words interchangeably, but legally, the third party should be known as the supplemental needs trust. Why? Because again, we're using this money to supplement and not to supplant benefits that we're receiving. So if I'm getting Medicaid, I'm getting SSI, and I have a trust, we're not using that to replace, right? Because if we do, it's very easy for the state says, I don't even think you need our benefits because you're using all your trust money. So we're using it to work hand in hand with each other. Have it been used? Yes. The implication is we're going to have an adjustment in our benefits. Special needs trusts usually is used when we're talking about the first party trust, where we're receiving an inheritance, where we're receiving a settlement from a car accident. And I may not have completed the thought with one of our questions. So the first party trust is usually used if you're receiving an inheritance and it wasn't created while the people were alive. You're creating it after the fact because they're saying it's already theirs. So-and-so already died. And in their will, it said they're supposed to receive it. So that's it, so we have to create a first party trust. When we help clients who are in a car accident and they're receiving a large settlement, that will probably disrupt benefits. Then you create the first party trust. it does have the payback. That's what we have to deal with. But yes, first party trust is when you have those. But yeah, that's typically the terminology you'll hear, special needs versus supplemental. Great question.
More
Um,
questions, Chris.
Sure.
Claire is asking, how would I know which kind of SNT I opened?
Typically you want to look well, if it was something that we did, you're looking for either the terminology, supplemental or special needs. It should be on the top. Is there a payback clause? Payback clause, that's first party. I wish I could say that's definitely the telltale sign, but as you had heard, we've seen trusts that were mishmashed together and they're putting in clauses that made you think of one, but it's really something else. So you have to read, and typically in the first page of the trust, it tells you what's it for. This was because I received an inheritance. This was because of the settlement. This is because I want to protect benefits. So if you hear those words settlement, inheritance, that's probably a first party trust. That's typically in the recital of the trust, because you have to put the purpose. Which leads me to one of the questions that were submitted earlier. I hope that helps, Claire. And one was saying, how can I possibly prove competence so I can end my special needs trust? So, each trust has a purpose. And when that purpose isn't used, it's not being fulfilled anymore, there is a process to terminate. So you have to read the trust, and there's a process of how to terminate. Generally, in years prior, you had to make an application to the court and to say that this trust, based upon, and they give you instances of when you can terminate. Unfortunately, the person died, or there's no more money in the trust, or the person, the use of it to protect benefits, there's no more benefits. They didn't need the benefits. So that's the reason why we would terminate. So Beth, I recommend that you look at the trust. There is a termination clause in there, and look through it and see if you fulfill that. Or, again, we've seen that in our office where we have to help interpret and go over, these are situations where you can terminate. Do you fit any of those criteria? That's a good question. Here's one from Karen. May I put my home into my daughter's third-party special needs trust before my home is paid off? Okay, so again, putting homes in a special needs trust, that is a common practice, but there's things that we need to be aware of, because again, because there's a mortgage, I do feel that causes a bit of a wrinkle, right? Because we're changing the title of the home. Whenever you change a title of a home, banks, mortgage company, they really sometimes take a very black and white approach. New name, that means there was a sale, so I do need you to pay up your loan. They're going to look for you to pay up the loan, the mortgage. Are there instances where there's an exception? And there are, depending on the trust. So we do have to be careful because there's a mortgage. My recommendation is that it really isn't a good idea when there's a mortgage to do that. I think it causes more problems, Karen. If there wasn't a mortgage, it could be a great idea. There's a lot more things that we have to ask, and there's a lot more situations that we need to see if it really is the ideal situation. But when we see homes being placed in a special needs trust, typically there's no mortgage. It's cleaner that way, less mess, less fear that the bank is going to call the loan. Okay. Hope that helps, Karen. Just trying to see if there's any more questions here.
Couple more, Chris.
Okay.
Question is there a limit to the number of withdrawals each year for the SNT?
Mm-hmm. Oh, no, there isn't. No, there isn't any limit at all. No, not at all. And that's the one thing with the trust. It's pretty much, liberal on that. So you're okay with that. Yeah.
And one more question from Count Carmen. When does a parent start putting in place to apply for SSI or Medicaid?
When does she, as the child becomes 18, that's when they become eligible for those types of benefits. Typically, there's always exceptions, but the reason is because at that age, we only look to the assets in their name. Younger than that, we're looking at the assets of who they're living with. So that typically disqualifies them. So you do want to start the process Typically there's a lot of paperwork to gather, Carmen, and everyone, as you know, a lot of medical documentation, a lot of things to put in place. I typically say 17 and a half. If you can start getting that paperwork, start gathering that, putting that together. And it's good to do it while you are considered that they're not an adult yet, because you can do it for them. Once they turn as an adult, there's going to be questions posed to them. There's going to be a request to have them come to the office of Social Security and interview them. So where I've found some help is where we've helped clients become guardians of their children. If we're in that situation where they may not be able to make decisions for themselves or communicate for themselves, an application for a guardianship is important. Guardianship is a process where we or someone is appointed to make the decisions for our loved ones who may not be able to, even though they're above the age of 18. So when I remember helping a family apply for SSI, they were having such a hard time. So they asked me, Chris, can you just help us? So we made the appointment. It was an 11 o'clock appointment, but we were not heard till 3 p.m. And thankfully, my client was guardian of her daughter. I couldn't imagine sitting there with her daughter. If we didn't have the guardianship, we had to bring her. Sitting there with her daughter, myself, the three of us for 5-6 hours, I was miserable. So I couldn't imagine that. So that was what I was grateful for. So I do take that to heart, that if we're going to make these applications, I do feel if we can start it while you are still able to make decisions for them, or if you can do it while you have the guardianship in place, that'll be great, because you can get the paperwork done for them. It is challenging. I think right now they're still doing things remotely. I don't know if they've opened the offices, Social Security, but at the time when I was helping, we were in, you're sitting there, even though we had an appointment. So just want to let you know. So yeah. And you're right, Laura. Good. Yes. And you're right. The yearly max is 16. They did change that. I have 15 in my brain, but 16 you can put in. But again, mind the accumulation of it to 100,000, 200,000, 200, more than 200,000, you're losing all benefits, just to let you know. Okay.
I believe it's 305,000 for that benefit.
There we go.
All benefits. Yeah.
Yeah. It's upsetting. Okay. Thank you. Let's see if there's another question here. Nikki, when and how does Medicare coverage begin? What is the criteria? So I'm not sure, Nikki, if you mean Medicaid, but Medicare, typically, again, in general sense, is when you're 65 and older. It's an entitlement that we've had, and there's different parts to it as to what's covered. So I'm not sure if that's your question, but if it's Medicaid, again, one of the big things that we have for our loved ones is that, it'll help them with the medical coverage, but we do have to have low assets with regards to that. And you want to start the application, sooner than later, before they're 18. If they're over 18, that's okay. Start the paperwork, but it may be easier, before that. I'm just looking.
Chris, we're going to let's time wise, just wanted to check.
Yeah, I think so too.
Yeah, absolutely. So, but we're happy to stay on for other questions if anybody has any other questions. But I think we can, we can just wrap up for the evening, and we're looking forward to doing another one of these so that we can have, hopefully Adam can join us again down the road, if that would be great. But I think we should wrap it up. And if anybody wants to stay on for more questions, we're happy to answer them.
Absolutely. And we'll put our information here in the chat. Adam, if you want to put yours, how people can reach you, if they had further questions or things they were thinking about with loved ones, maybe we'll put that in the chat, how to get in touch with you.
Absolutely will do. I thought this was great. Thank you to everybody who participated, and feel free to follow up if I can be of assistance in any way. I'll send my info in the chat. Have a good night, everyone.
Good night, Adam.
Everyone.
Thank you, Adam.
Thank you. Thank you. Let's see here. Okay, and I'll put this put our email address here if you would like to reach out. Okay. All right.
I see there was a question here by H. Wilder. Maybe we can answer that really quick. I think he or she is still on the line right now. So Chris, what's your opinion of a purely discretionary testamentary trust? No standards for Medicaid purposes.
Well, I think, those are great. And again, if we're not looking for a special needs situation, because, those are very particular, you have to have certain terminology. But Chris and I have dealt with those types of trusts, especially when you're helping with people with long-term care planning, right? If we have someone who's saying, you know what, I'm concerned about long-term care costs. So those are the types of trusts that we can create, and it doesn't have to be as elaborate, or it doesn't have that type of terminology that special needs trust planning has to have. I don't know, Chris, if you have an opinion, you do a lot of those actually, Chris, probably more than I do, I have to say.
I do. And quite honestly, I think that a testamentary trust is not a terrible thing. Now, one thing that people are not aware of in New Jersey is that wills, which is where testamentary trusts are created by will, they become public records. So oftentimes, you're not that you're at the mercy of the court, but it becomes a public document what the trust is. Typically, when you have trust, it's really private. If you establish something called a standalone trust, which is kind of a document by itself, and then you create your will that actually transfers whatever assets you have into that trust, you're actually able to protect some of the details about that trust from becoming public knowledge. So I typically prefer to have a standalone trust, so nobody has to know about the details of who you're giving your money to or how the money is supposed to be spent, because these wills are out there. They're out there for people to see. But sometimes people say, you know what, I really don't plan on funding a trust right now. I just want something that's effective when I pass away. Well, then a testamentary trust, at least for a special needs perspective or any kind of perspective, really does the job. If you're really just trying to create the trust in the event you pass away, and certain situations are actually in place. But when it comes to Medicaid planning for yourself, that's definitely not the way to go, the testamentary trust. And, I would like to offer you a time to chat with us about, what that entails, because that is something that we really specialize in at our office.
I think the one thing I always notice with the testamentary, I think it helps in many situations, but I think where it's short is, the issues of successor trustees. What are the instances? Like, you can get really detailed in a standalone trust about all these situations that could happen. So it's sometimes a little bit too general, everyone's, situations is different, but I do think it serves its purpose for certain situations. But for some reason, I've always been a big advocate for the standalone, but everybody's different. So,
Yes,
but good,
absolutely.
thank you so much. We just think anything else?
Okay. Any other questions for
trying to
us?
make sure
We're
we hit
happy to
everything.
answer. Let's see.
Carmen, it was nice talking to you. I was gonna say see you, but I hear your voice, so that was good too.
Okay.
See here. I think that was it, right, everybody? Okay, everyone, thank you so much. I appreciate everyone's time, and this was fun. We love to do this. So if you have any more questions, please reach out. We're happy to chat and see what we could do to help you and your family. Thanks, everybody. Have a great night. Yes, Carmen.
Take care,
I was going to say
everybody.
that. I didn't want to say it in an open forum, but yes, absolutely.
Have a good night, everybody. Thank
Good
you for
night,
joining
everyone.
us.
Thanks so
Bye.
much. Good night. Thank you, Chris.
Thank you, Chris.